position.
Recording is on.
So there should be no market players with a dominant position, because if you have a dominant position, then then you have no choice, and when you have no choice, you have no competition. You are very well aware of computers and the internet, and there are some really, really big players, including Microsoft and Google. And there have been several cases with Microsoft and Google, involving Microsoft and Google, where they were accused of having abused their dominant position. For example, with Google's search engine, or with Microsoft's Internet Explorer or new browser, which is called Edge. And often when you got a new computer and you started it, you installed it, often they didn't give you a choice. You automatically had all the Microsoft products, including the Microsoft search engine, which is called Bing, including the Microsoft Internet browser. When you now buy a new computer and you start the system, you install everything, they give you a choice. They ask you, which browser would you like to use? Which search engine would you like to use? But for many years, this was not possible. Microsoft only promoted their own products, and so did Google. And competition law was what changed the game, really, that we now have a real choice. Anti-competitive agreements, of course, companies can also negotiate behind the scenes, and they can enter into certain agreements that have an anti-competitive effect. And this is also to be prevented by competition law. Merger control is a topic as well. So, of course, when major companies merge, it is always a question, how big will they get? How dominant will they get? Will they create a monopoly? Because the monopoly is exactly the opposite of free competition. So merger control is also one of the big topics that we have when we have companies of a certain size that want to go together, that want to merge, or company A wants to buy company B. From a certain size, there is merger control. Many of these big transactions need to be approved by a national competition authority. I will show you what authorities we have and give you a few examples. Yeah, and of course, enhanced consumer welfare. I mentioned that before. One of the people, or the main people to protect really are the consumers, because having no choice is bad for consumers. Having no competition is bad for consumers. So consumers benefit from competition, and markets benefit from competition. A brief look into the historical background. So in the United States, the main legislation, also the first legislation enacted in 1890, was the Sherman Act. And in the European Union, we have got the Treaty on the Functioning of the European Union, the TFEU, Treaty on the Functioning of the European Union. And in there, we have two articles dealing with competition law. And these are the articles 101 and 102. And then, of course, globally, many jurisdictions adopted competition laws, including your country, Uzbekistan. I checked it a little bit on the internet. So you've also got your competition authority, and also you've got your topics. And the competition law topics are pretty similar around the world, So what we are talking about here, when I talk about the US or the European Union, the rules established pretty much work around the world in most countries, in very, very similar ways. The Sherman Antitrust Act, 1890, reads in Section 1 as follows. Every contract, combination in the form of trust or otherwise, or conspiracy, in restraint of trade or commerce among the several states or with foreign nations is hereby declared to be illegal. Every contract combination in the form of trust, so here we have the American word for cartel, trust or otherwise. Conspiracy is when you secretly, agree with someone on something which is not okay. In restraint of trade, this means which really prevents or hinders or impairs trade or commerce. This is declared illegal by Section 1 of the Sherman Act. And Section 2 says that every person who monopolizes or attempts to monopolize or combine or conspire with any other person or persons to monopolize any part of the trade or commerce shall be deemed guilty of a misdemeanor. Now, I don't know whether you've heard the word misdemeanor before. This is a word from US criminal law. The crimes in the United States fall into two categories. We've got felonies and misdemeanors. And what you can basically say is the misdemeanors. Hello, you must switch off your microphones. Please mute yourself, otherwise we will hear what other people are saying. Yeah. So whoever has an open microphone, mute it. So here we've got trade or commerce with foreign nations shall be deemed. So we've got two types of crime in the United States: felonies and misdemeanors. Basically, the felonies are the more serious crimes, and the misdemeanors are less serious crimes. But they are still crimes. They are still crimes. Let's go to the European Union. These examples are from, let me just see whether I can do something about this. I'm just trying to find the open microphone here, and then I will. Boom. Okay, great. So I was just able to use my power to mute. So let's go from the US to the European Union. Yeah. Here you see the two articles in the Treaty of the Functioning of the European Union. And here you have a very basic explanation that antitrust rules prohibit agreements between market operators that would restrict competition and the abuse of dominance. So we've got the main topics here: restriction of competition and the abuse of dominance. Yeah. And then we've got the two central rules, which we have in the Treaty on the Functioning of the European Union. We've got Article 101, which prohibits agreements between two or more independent market operators which restrict competition. And this might involve a cartel who does price fixing and or market sharing. Price fixing is a big issue also in competition law. This occurs when two companies just talk about prices, or two or more companies, and they have a specific product, and then they fix prices. And when you fix prices, of course, you don't allow competition because there is no competition. If everybody charges the same price, this is anti-competitive behavior. Yeah. And the other article here in the European Union is about the dominant position. So they are not allowed to abuse such a position, for example, by charging unfair prices, limiting production, or by refusing to innovate to the prejudice of consumers. So these are the main rules that exist in the European Union and in the United States. So the Treaty on the Functioning of the European Union in Europe and the Sherman Act in the United States. And here you see one of the things that, in this case, the Commission and they mean the European Commission as the regulatory authority in Europe, what they can actually do. So here you see some of the powers and some of the tools the Commission has. They can, for example, inspect businesses. They can ask for information. They can impose fines. This is a very, very important tool. A fine is a money penalty. So companies engaging in anti-competitive behavior can be fined, as we call it, which means they can get a monetary penalty. And this is basically it. Interesting word is the word leniency. When you are lenient, you are very generous to somebody. So leniency means you would be punished or fined, but if you cooperate with the regulatory authorities, they can either reduce the fine or say you don't have to pay the fine, you know? This is an encouragement, as you can see here, to hand over inside evidence of cartels in exchange for immunity. Yeah. So either immunity, this means you don't have to pay a fine, or you get your fine substantially reduced. And this is when you cooperate. Yeah. Maybe you know the word whistleblowing right here. Whistleblowing is a standard term, standard English term for disclosing information. Often you can do it anonymously, or you can also do it knowingly, that people know you. Of course, when you want your fine to be reduced or even waived, you will identify yourself. Yeah, but whistleblowing is quite an important source of information for the competition authorities. Of course, you can settle a case, which means you can find an agreement. So cartels can acknowledge their involvement. And if they acknowledge that, they say, yes, we have done that, we have participated in a cartel, they can get a 10% reduction in any fine which is finally imposed. Okay, so these are some of the key words: inspection, request for information, fine, leniency program, and of course, here again, investigations, whistleblower, which helps really the regulatory authorities to get information. And then there's always an outcome. So either a case is settled or a fine is imposed. Just to give you the text of the article, so this is what it reads in Article 101 of the Treaty on the Functioning of the European Union. And then they list a number of things which are incompatible with the internal market. Yeah. They use the word undertakings when they talk about companies or businesses. Yeah. So when they apply concerted practices which may affect trade between member states and which have as their object or effect the prevention, restriction, or distortion of competition within the internal market. So this is just the wording of the article. And there are also a couple of examples, of course. So one of the things is price fixing. This is definitely illegal. Controlling or limiting production, markets, technical development, or investment. That's also stipulated as illegal. Sharing markets or sources of supply is another point. And to apply dissimilar conditions to equivalent transactions with other trading parties, placing them at a competitive disadvantage. Yeah, then when you conclude contracts and you put pressure on another party, yeah, which has also this detrimental thing against competition, then that is of course also not allowed. And then of course any agreements or decisions prohibited pursuant to this article shall be automatically void. This means such agreements, such decisions are automatically not valid. The legal term for this is void. I'm sure in your studies you've heard about valid agreements and void agreements, or valid contracts and void contracts. Here again, very brief overview of the core areas of competition law. So we've got agreements about price fixing, market allocation, or forming cartels between several businesses or companies. We've got the dominant position topic, which puts a company into an exclusive position. And exclusivity also means this is anti-competitive. And then, of course, the third point here, the merger control, you want to avoid monopolies. Monopolies always mean there is no competition in a specific area. And then, of course, in order to avoid such monopolies being created, mergers are regularly reviewed, and they are also subject to approval. And this pretty much works in most countries around the world. If you want to look into this a bit further, here are some notable cases. So here's what, for example, Microsoft was subjected to in the European Union. Abuse of a dominant position was the issue here, because when they presented their operating systems on their computers, at least in the past, there was a problem of interoperability. So sometimes you couldn't use certain software on a Microsoft computer. You were forced to use Microsoft products, search engines, internet browsers, and this is no longer the case. Quite a big case in the United States, just if you're interested, you can Google that, was the United States versus AT&T, very, very big telecommunications company. There was a monopoly there, and they broke it up. And one example from India includes the DLF case, and this included abusive clauses in buyer agreements. But these are just some cases if you want to look a little bit further. A quick look at some competition authorities. So in the EU, there's the European Commission. In the United States, the Federal Trade Commission. India has its own commission. It's called Competition Commission of India. And most other countries have also some competition authority. They all have a number of powers, which include investigating a matter, imposing fines, and then, of course, structural remedies. Structural means they can change the structure of companies, or if they find monopolies, they can break them up, and so on and so forth. Here are a few examples of what happened in Germany in the last years. Just to give you a few examples, here we have, for example, several road repair companies that entered into cartel agreements because they did something. You see it here, bid rigging. This is a very complicated word, bid rigging, and I really need to explain this. Now, usually, when there's a contract to be awarded, especially a public contract, there is what we call a tender. A tender is an open invitation to companies to submit offers in order to win the contract. For example, there need to be some roads to be constructed or repaired. The responsible ministry would invite offers. So they would put out a public tender, and then companies make offers. These offers are called bids. Bid is just another word for offer. And then when you engage in bid rigging, this is something anti-competitive and illegal. Bid rigging means the companies that submit their offers, their bids, they talk to each other and they agree, for example, in which region one company makes an offer and in another region another company makes an offer, or the best offer. So they kind of divide the market by themselves, not by freely competing, but by simply agreeing on a specific market share, that they say, okay, this region, you will submit the best offer, and that region, we will submit the best offer. And by that, we all get a little bit of the cake, a slice of the cake or a piece of the cake. This is called bid rigging. Yeah? Companies should always submit their bids, their offers, independently. And they should not talk to other companies. Oh, what offer are you going to make? Shouldn't we agree on something, that we all get a little bit? Yeah, this is bid rigging. And as you can see, there was a 10.5 million fine that the German Federal Cartel Office, which is called Bundeskartellamt, that the German Federal Cartel Office imposed on 7 road repair companies that conspired. They did bid rigging. Another example is a 6 million euro fine on an electronics company or on several electronics companies for price fixing, So they also talked to each other and they simply fixed prices for audio products. Here we have a case of merger control. Here we had a bank being interested in acquiring a major stake or share in a German bank. It was almost 30%. And this was subject to control by the cartel office. And in this case, they cleared the acquisition, which means they approved it. So the